So, good morning. I'm here today to present to you a short symposium piece I'm preparing about patent working requirements. And I'm talking about patent working requirements, also referred to as local working requirements, sometimes referred to as compulsory working. The goal of the article is to look at patent working requirements from comparative and historical perspectives, and to see what comparison across multiple legal systems can teach us about patent working requirements and their role in the larger patent system. We see today patent working requirements often discussed out of any context. And my probably most important point in the paper is that that's a mistake, because patent working requirements play different roles in different patent systems, and we should keep that in mind. It's very difficult to take them out of a patent system or insert them into a patent system without considering the interplay of these requirements with other elements of patent systems. So I will talk briefly about, historically, about the interest in patent working requirements, about their different functions as they developed through the decades, and talk about the interplay relationships with other elements of the patent system. In fact, surprisingly a lot has been written lately about patent working requirements, perhaps not surprisingly because of the non-practicing entity, patent assertion entity phenomenon. A number of authors consider whether patent working requirements should be introduced in the United States to mitigate the impact of the activities of non-practicing entities, and how that might help some of the issues that we have seen. Before this latest wave of interest in patent working requirements, there was another island of interest in patent working requirements in the early 2000s, which was when we had the US-Brazil dispute before the WTO about the Brazilian patent working requirement. However, as many of you probably know, that dispute got settled, and so we still don't know really what the status is of patent working requirements and their compliance with the TRIPS agreement. As Stefania Fusco mentioned in her earlier presentation today, authors actually disagree on whether patent working requirements are in compliance with Article 27.1 of the TRIPS agreement or not. The question is still not answered. Another little interest in patent working requirements we observed in the early 1990s, when the United Kingdom was taken to the Court of Justice of the European Communities at that time, because of its own patent working requirement that was found to be not in compliance with the EU, at that time, European Communities rules, and the UK had to change the provisions about patent working requirement. So it's an interesting fact that in the second half of the 20th century, we saw quite diminishing interest in patent working requirements. Of course, that was primarily caused by the fact that although they were quite a contentious issue at the beginning of the 20th century, the Paris Convention tamed them quite a bit. It was actually one of the biggest points in the discussions of the revisions of the Paris Convention, and eventually the 1925 Hague revision of the Paris Convention achieved the provision in which patent working requirements should be more connected with compulsory licensing than forfeiture of a patent. So that, of course, caused diminishing interest in patent working requirements. As many of you know, many countries had patent working requirements, or still do, but even nominal working and very minimal nominal working would satisfy the requirement. The TRIPS agreement, again, doesn't directly address patent working requirements. It doesn't say anything explicitly about them. But again, some commentators suggest that Article 27.1 and other provisions of the TRIPS agreement mean that working requirements should be gone. So what were the functions of patent working requirements through decades? Well, the first and important function of patent working requirements was disclosure. So that's from the very old days when a patent was really a tool for countries to bring inventors in, or entrepreneurs in to teach the nation, right? So the concept was an inventor as the teacher of the nation, somebody who should come in and teach the art to the nation. Working requirements were preconditions of old patents in Italy, in England, but were gradually replaced with the disclosure requirement. So as patent systems became more sophisticated and patent applications provided sufficient information for somebody to replicate the invention, working requirements started losing at least that important function of teaching or disclosure. The next, of course, important function is protection of domestic industry, and here we are talking about the function from the times when patent working requirements had to be fulfilled by local manufacturing, right? You could not really use importation to fulfill the requirements. Of course, that was the most problematic function, the one that the industry liked the least because it was problematic, it was burdensome, often not really economical to produce, manufacture something in the given country. But the function was important, right, including, for instance, from the perspective of job creation, employment, so another important function. Another function of patent working requirements is access. The need to secure that a country will have access to the invention, to the technology. And again, that function persists. Again, local manufacturing now can be actually replaced by importation, but that's fine if you are looking at the access function. As long as the country population has access to the invention, to the technology, that's enough. Another function, the last one that I identified, not sure how to really call it, I call it strategic national security considerations. Probably will send a completely wrong message, so you can suggest some other appropriate term for that. So what it is a fear of displacement of an entire industry in the country. And a good example of that will be the reintroduction of the patent working requirement in the United Kingdom in the early 20th century in reaction to the expansion of the German chemical industry. So the concern that there is access, right? The chemical inventions were available in the UK, but the UK government saw an entire industry being taken over by foreign manufacturers. So it's a little bit different from the access concern, right? Because at least currently the country would have access to the invention, to the technology, but there is again this concern that an entire industry or a field of technology is being influenced by either a state, a country, or it can be also, and that's even more interesting, a non-state actor. It could be a multinational corporation that is actually occupying an entire field of technology or an industry. So the different functions influence how patent working requirements play out in the entire patent system. So let's look at some of the relationships of the patent working requirements with other elements of the patent system. And again, this is where I see a problem with some of the proposals or suggestions for patent working requirements being either abolished or introduced in some countries, that we really seem to lose a little bit of the perspective about why patent working requirements exist in some of these systems and how they play out with other elements. So I mentioned disclosure earlier. Again, theoretically, the more disclosure you have of the invention, the easier it is for the population, for the country, to learn from the patent application and from the issued patent, the less you need patent working requirement. It might be a fun thought experiment to think about this particular relationship now when we have so many doubts about the disclosure function, notice function in our patent system today. Another one is patentability, which is rather a pedestrian relationship when you think about it, but it's a very important one. So, for instance, in the early 20th century, many countries criticized the UK for the introduction of the patent working requirement. Well, many of those countries had no patents for chemical inventions. So they could not really relate to the concern about the German chemical industry becoming stronger back then. So certainly if countries have ways to limit patentability, of certain inventions that they consider strategic, important, and so forth, the less likely they will be interested in patent working requirement. We can think currently, for instance, about India and their approach to patenting of pharmaceuticals as one of these examples. Another interesting point in this context, by the way, is the unitary patent in the European Union, where some of the smaller countries are currently thinking about not ratifying the agreement and staying out of the system, precisely because they figured, well, if we can avoid having certain things patented in our country, we will face less of the problem with patent work. Compulsory licensing, of course, relates to patent working requirements very closely. The Paris Convention expressed the preference for compulsory licensing to forfeiture. In fact, it seems that countries that had licensing early, compulsory licensing instead of forfeiture, were likely to have patent working requirements less strict, because they figured that it will be easier to do compulsory licensing. Here, of course, the recent developments with standard essential patents are interesting, including in the EU. Injunctions, perhaps one of the most important points. It is important to realize that there are countries where courts have no discretion when it comes to injunctions. In Germany, if you're a patent owner, your patent is valid and infringed, you will get an injunction. That's it, right? The court has no discretion to deny injunction. In those countries, of course, patent working requirements are extremely important because those countries will have not the corrective mechanisms that we do, or we should have, through the discretion in case of injunctions, to deny injunctions when some of the functions are important. Competition law, of course, might provide remedy in some cases, but usually only for standard essential patents. So again, that's why you need a patent working requirement in some of these countries to actually serve the purpose that injunctions might serve in other countries. License of right is another important element of a patent system that relates to patent working requirements. In some countries, such as the UK, and now also for the European Union unitary patent, you can register a license of right, which actually serves somewhat like a promise in case of a standard essential patent. It creates an obligation similar to the standard essential patent obligation. The question is, well, the relationship is there. Do you need more stricter? Do you need more likely a patent working requirement or less? Well, in fact, the patent working requirement in those systems serves as an incentive, right? So in the UK, we see companies registering the license of right in response to the existence of the patent working requirement, because if you register license of right, you are not likely to be attacked under patent working requirement under lack of working of patent. And finally, exhaustion doctrine, right? There is an interesting relationship between exhaustion doctrine and the patent working requirement. Countries that have national exhaustion of patents and the right of importation are or should be more likely to have strict patent working requirements, right? So the idea is a patent owner has to work locally, which can mean both importation or manufacturing. But the patent owner at the same time is protected against parallel imports, right? So there's national exhaustion. Countries with international exhaustion arguably should be less likely in need of patent working requirement, because even if the patent owner doesn't work the patent in the country, as long as you can import from other countries, from patenting from the same inventor, patent owner, you don't have to worry at least about the access function. So again, this relationship would be interesting to consider in light of the various functions, and that's what I will try to do in my paper. So in conclusions, I think that we should look at patent working requirements in different patent systems, what kind of goals they serve, what kind of functions they serve, and consider what we want to achieve if we were to introduce patent working requirement, and how it would play out in relationship to various elements of our patent systems. The messages are really only two. One size does not fit all. And the second groundbreaking conclusion is if you have a complex system, it might be difficult to take out one element without considering its relationship to the other elements. Questions? Yes,
I really enjoyed the presentation. I was interested in thinking a little bit more about the relationship between the disclosure requirements and the working requirements. You mentioned that as patent systems became more sophisticated, they moved away from working requirements into disclosure. So I'm imagining that the disclosure at that time was pretty robust. And so I'm wondering if there's been a study done, or maybe you might consider thinking about kind of the waxing and waning of the robustness of the disclosure requirements and how that affects whether a patent working requirement is implemented or discarded. And I imagine that that may change over time. Perhaps they discard the working requirements, and then as the disclosure requirements become more lax, perhaps they reinstitute it. And so I was hoping you could speak a little bit to that.
Thank you. That's an excellent suggestion. Cannot speak to it at all, but I will take it as a suggestion. Thank you.
Well, it's along the same line, so and I hope we don't get stuck on the disclosure side, but it's sort of interesting. I understand the relationship between the two. If the goal is to get the technology introduced to a particular country or area, but in some ways, the working requirement is sort of, think about it conceptually, is sort of a post-issuance reduction to practice requirement as well, right? So in some ways, it's almost a heightened disclosure. It's not because with enablement and that sort of stuff, there's still some uncertainty as to whether that it could actually work or not. Whereas this seems to say, no, this is actually a supplemental disclosure requirement in that you actually have to make it, right? Otherwise, it's not going to have any value at all. And so that just thinking about that tension between the two, that it may not be this simple trade-off between the two, that actually, because it has to, you're going to make something. It is like a post-grant reduction practice requirement, which we might think of differently.
I think you're absolutely right, and actually, I think the simplistic sort of view of the trade-off disclosure patent working requirement comes from the days when inventions were just easier, right, and simpler. And I think it's particularly interesting today when you think about some of the pharmaceuticals and the difficulty of replicating results. In that context, it might be interesting as well.
So I wonder if there's a distinction between a working requirement and a local working requirement. And I mean, as I understand the proposals for a working requirement, if you will, in the United States, I've never seen them as working it in the United States. Maybe I'm wrong about that. Is there are the historical or comparative examples of working requirements always local working requirements, or is there any historical example of simply a working requirement wherever it's worked? Because it seems to me that the justifications, the downsides, all of that differ between a local working requirement and anywhere working requirement.
Right. I absolutely agree. Certainly the possibility to supplement or to fulfill the requirement by importation came later, right? And it was sort of the end of the 19th, beginning of the 20th century, when the idea was that it might be simply impossible to import. It's funny because one of the authors who wrote about, criticized patent working requirements about 1911, he used as an example of why it's not wise to require patent owners to practice the invention manufactured in a country. He used Panzer, which is, how do you call it in English? It's what you use for tanks, the metal, which, 1911, sort of sad thing to read.
So when you say that, I'm going back to the disclosure question, when you say that that patent systems sort of dropped this working requirement when they moved more towards paper disclosure, what period of time are you thinking of? Are you thinking of in the 18th century, or are you thinking in the 20th century?
Oh no, that came actually in about the 1830s and 1840s is when a lot of these patent systems dropped the working.
Well, I think the history there may be a little bit more complex because the leading commentator on U.S. patent law, Robinson, denied that you could have constructive reduction to practice, actually, in his treatise in 1890. So it's much later in time that, not exactly a local working requirement, but a requirement that there be actual production, was in U.S. law. It was a controversial thing at the turn of the 19th to 20th century. So you might want to look at that. And even in the early 20th century, throughout most of the 20th century, U.S. law discriminated negatively against patents that were mere paper patents. And that was a type of working requirement, though not a local working requirement.
Thank you. So that goes back to the enablement.
That's right. Yes, it was. I think it was never really articulated in that way. And Learned Hand was actually one of the leaders of the charge that destroyed this doctrine. Because I think, in part, because he was a good lawyer, because he thought that there was no legal basis for this, even though I think you might be right that there's actually an intellectual case for this, even as requirements.
Well, and yes, but thank you.
Yeah, and just going back, another perspective is Herb Hogenkamp has written a fair amount about the working requirement, and most recently in his response to Richard Epstein's book on the classical Constitution. But he talks a lot about domestic U.S. working requirements and the changing landscape throughout the 19th century there. So that's another historic source. He presents his own view of that.
Just as a reaction to both of the comments, there's another important point from which I want to stay away because I would never finish a symposium piece, which is that there are other, of course, tools in the patent system that work quasi-working requirement. Thank you very much.